Welcome to the official Lawyer Minds podcast. Lawyer Minds is an ever-growing ecosystem for all the resources modern lawyers need. As the official Lawyer Minds podcast, we'll discuss everything from the latest happenings on the website to industry news. Get ready. Here we go. It's time to dive into the minds of successful lawyers. Here are your hosts, Tad Thomas and Mike Campbell.
Mike, welcome back.
Hey, how are you?
I'm good. Just a few weeks ago, was out at the AAJ convention in Las Vegas. Sorry you missed it.
Yep. It sounded like a great time, but I was going from one jury trial to another.
It was a great time. AAJ budgeted to have about 1,000 people there because we just didn't know what was going to happen because of COVID, and we had over 1,800 ended up showing up. So had a great crowd. CLE was good. It was great to actually see everybody. It's like seeing family that you hadn't seen in 18 months.
It's amazing that how much you feel like you take for granted when you don't get to go do that stuff. And I went to the MATA conference at the end of June. And honestly, I was kind of like dragging my feet because we were doing focus groups and I had other stuff going on for these trials. And once I got down there, it was like a whole new energy. And I realized how much we lost last year.
Yeah, you get invigorated, being in that atmosphere and, seeing other people do good things. At our luncheon, AAJ gave a big award to Ben Crump and Tony Romanucci and all the team that represented the Floyd family, which it was a big team. There was, probably 10 lawyers involved in the case. But they got an award. We got to hear from the Floyd family. It was really, really nice. It was a great event.
Yeah. And it just goes to show how plugged in AAJ is with everything. I remember reading, sort of a synopsis of the convention and then all the things that happened. And, that was a major part of it, was recognizing the Floyd family and what happened there. But then there was also, hey, we've still got to battle COVID immunity. So let's talk about that. Got their AJ's massive, right? But when you go, it does feel small. Like you said, you feel like you're with your family, but it's impressive the reach that the organization has.
Yeah. So today we're going to talk to Jamal about an incredible case that he's got going on down in Texas involving some shootings in Silver Springs. I got a chance to do this interview. I think you were in trial when I did it. So incredibly interesting from a number of respects. One, just because it was a tragic case, and he'll talk about, what happened. But the fact that it was a Federal Tort Claims Act case, which I'm not very familiar with. I don't know that I've ever even handled one. I know I've never done one all the way to a hearing like they did. So he's going to talk about that. And then now they're, set up for a month-long damages trial. It's crazy.
Yeah. When I hear FTCA, I run,
right,
because it's very scary to me, but I watched the podcast and I immediately started messaging Brian Jasper in our office because he has handled them. And hey, Brian, we've got this case. I just watched this podcast. What about this, that, and the other? And he knew all the angles. But if you haven't handled an FTCA case, this is the podcast to listen to today for you, because it is very informative.
And I texted Jamal after we recorded the interview because the same day I recorded the interview, I got an FTCA case called in. And then the very next day, we got another one they called in. I was like, I've been doing this 20 years and I don't remember the last time I had one that thought was an FTCA case. And then here I interview him and we get 2 in 24 hours. So
that's right.
Crazy.
Destiny.
Yeah. Well, let's listen to the interview with Jamal Alsaffar and the Silver Spring shooting case. Jamal, thanks for being on the podcast. How you doing?
I'm good. You're welcome. I'm real honored and glad to be here.
Why don't you tell us first about your firm, Jamal, where you all located and what kind of practice you all have?
Sure. Well, we're based out of Austin, Texas, and the firm Whitehurst Harkness. We also go by National Trial Law. We've actually we are about to celebrate our 50-year anniversary as a firm. So, I believe we're the longest serving personal injury firm in Austin. Our firm, we practice personal injury and catastrophic injury cases, state cases all over the state, and about half of our practice as well, which consists of most of our national practice, is Federal Tort Claims Act cases, which primarily involve military families and veterans, whether they've been malpracticed at VA hospitals, Army hospitals, Navy hospitals, or any time the federal government is the bad actor.
How'd you all get into that? It's a pretty specialized area. How did that come about?
Well, like a lot of things, by accident.
Right.
Well, I'll tell you, it's a story that's probably familiar to most, because I talk a lot about the Federal Tort Claims Act to our brethren around, and they ask that same question: what is this thing called the FTCA, and how the heck did you fall into it? And about 20 years ago, I would say it's almost 20 years ago, my partner had got a call from an Army family who's suffered a severe brain injury at birth. And it just so happened about an hour and a half north of Austin is one of the largest military institutions in the United States. It's Fort Hood, Texas. Darnell Army Community Hospital is the hospital. And the family, which is active duty family, had suffered a terrible injury to their child at birth. And our firm was taking birth injury cases all over the state. So we took the case and started looking into it and found out, it's a federal case. It's they sort of looked up this Federal Tort Claims Act statute and took the case. And the long story short, got one of the largest verdicts in the FTCA's history for that family. And it so happened that while they were trying that case, got another one from the same hospital, same Fort Hood, birth injury case, and in back-to-back trials virtually got 2 of the largest verdicts for these military families under that statute. And it was just really, one was a referral and one was just came across the office, and they just we did the research, figured out how to work the statute, and were kind of taken aback because we had never seen it before. After those cases, we realized that the military families were not really being represented in trials because of a lot of trial attorneys were scared of, understandably, of 2 things. This was in federal court, and it was a bench trial, and that was something most of us are taught from law school to avoid. Right. So we learned not a lot of good trial lawyers were representing these families, and we just kind of let it be known that, hey, we'll take a look at these cases, and that's where it started.
And the Ferris Doctrine keeps those cases out of state court, right?
So no, the Ferris Doctrine does keep a lot of cases out. So right. The Ferris Doctrine is the doctrine that bars active duty military folks right. who are injured from filing suit at all, which is a wrong decision, is one of the most criticized federal court decisions in the United States. But let me give you an example. Why can you file one if a military family calls? Well, if the enlisted person is the father of the child or even the mother in most circuits, then the child's claim can go forward, even though the family has a claim as well, and the family's claims are derivative, they can still go forward. So it's only when the active duty member is the actual one injured where that doctrine bars it.
Okay. So tell me about the Sutherland Springs case. There's this tragic shooting in 2017. Tell us kind of generally about the facts of the shooting and how this became a case to begin with.
Well, just before Thanksgiving in 2017, we had one of the worst mass shootings, and it's the worst mass shooting in Texas history. It's the worst church mass shooting in the country, and I hate to categorize it that way, but that's how we do mass shootings now. Is we have to do them in categories. Sutherland Springs First Baptist Church is a one stoplight town in the middle of nowhere, Texas. It's about an hour north of San Antonio, about an hour, 2 hours south of Austin. To be fair, I didn't know where it was. So, and the Baptist church is this one tiny steeple chase, little house on the prairie looking church that is sort of the community. It's about a community of 600 or so folks, and the church is where everybody goes. And on this Sunday morning, the shooter walked into the church with an AR-15 and killed 26 people and injured 22 others. So how did we get this? How did we get involved? My wife and I, Laurie, who's also my partner, we heard about it on the news, and one of the first things we heard was that the shooter was recently discharged from the Air Force with a bad conduct discharge, but he was discharged with 2 felonies on his record that they convicted him of. He abused his wife and his child. And whenever you are convicted of a felony, you are required by that convicting agency, in this case, the Air Force, to report it to the FBI gun background check system. And the government did not. They didn't report it. What that system does is it bars you from purchasing weapons of any kind at federally licensed firearm deals. So Dick's Sporting Goods, Academy, all those kinds of places that sell guns. Because they have to do a background check, and then if you pop up as a felon, you're subject to arrest, but you're certainly denied purchasing guns. So this shooter bought all of his weapons that he used to kill all our clients and all these family members at a federally funded licensed store that ran a background check on him, and it passed because the Air Force didn't report him. So we immediately said, well, that sounds like an FTCA case. The federal government and negligently operated its background check system that they required mandatory duty to do, which was important because under the FTCA, it has to be mandatory. And as a result, he was allowed to buy those guns, and they're the only guns he used to kill everyone. So that's how it started. We immediately started looking into it from that standpoint and letting it kind of get out there that, hey, this is a Federal Tort Claims Act case, and you need to make sure you do this right, or otherwise these claims are going to not be presented properly. Right. And so that's how we got in. That's how we got involved. And eventually we were appointed by the court to be lead counsel in the case.
I was going to ask you about that. There was a slew of attorneys, I'm sure, with that,
yes,
that many victims. How did that work with coordination?
Well, as you know, this can be really complicated, and
right.
And I'm just not one of those that likes bullying my way into those kinds of things. I always like to work with people I like, and I like to work cooperatively. I got a few calls from some of the other big lawyers. I mean, there are some fine lawyers working on this case, some of the best lawyers in Texas too. And so I first of all, I talked to a lot of the families and met with them, and that was the first thing. Several of them wanted me to go forward on their behalf. And then once some of the other lawyers who had several contacted me, we just started talking about how to approach it and how it worked and how we're going to do it from a federal standpoint. And thankfully, I mean, I'm very humbled by it and grateful, but it was very straightforward. Several of the lawyers said, you know what, we know you, we know your background, we know what you've done in this area, and we'll support your leadership in it. And I have to tell you, that has not always been the case in these kinds of cases, as you know. And I have to say that my co-counsel on this case, who are every bit as good, if not better than me, have always been we're all rowing in the same direction almost from day one. So that's how it happened. With their support, we went to the court, and the court appointed us. And so we just took off from there.
And then, so since it's a Federal Tort Claims Act case, like you were saying earlier, it's a bench trial, and it was a bench trial during COVID, right? Yeah.
So the court bifurcated it. So we had to try after getting through 3 years of crazy litigation and all kinds of government federal motions to dismiss and summary judgment, we actually won a partial summary judgment, which was really interesting. Oh, wow. But then the court bifurcated it because of a lot of reasons. We had a lot of witnesses. We had COVID, and the judge was very concerned, and I appreciated this about some of our elderly clients. He wanted to move forward on this. So he bifurcated liability. And so that's the trial we just had and won. We just heard we won, but did a hybrid. It was in April. So we had to do a hybrid in-person / Zoom trial. So, which I thought was interesting. I'm not sure that might've been the first one in federal court, at least. So we were in person, the lawyers. Half of the witnesses were in person and half were Zoom. We had all protocols, masks and plexiglass everywhere. And I can say that it really went well and smoothly. It really did.
So the technology in the courtroom allowed, the internet was okay, it wasn't jumpy, didn't have any problem bringing in witnesses?
Well, there's an interesting story, because right before this case, the same courtroom, or not the same judge, but the same court, had just tried a very small medical malpractice Zoom trial, and it didn't go well. It was very spotty. The judge was worried about it. So, what we did ahead of time and to overcome those hurdles is we have an excellent trial technology team that I've been using forever. Wherever I go for trial, I take them with me. We just said, Judge, let us try to figure out the best way to make this smooth, and we'll take that responsibility on. And what we found out was we started working with the court's IT staff very early, well before the trial started. And we started running tests with them. And then we ran a lot of tests with our witnesses that we were calling by Zoom, with the IT guys that were working with the courtroom and ours uniformly. And we found there were a lot of bugs. We resolved all those bugs and then retested again. So it was really about making sure we made ourselves available to run in real time the actual witnesses with the courtroom staff, because the courtroom staff learned, they did a great job of figuring out, some of this was on our end, we need to fix that. And then they figured out, some of the problems are actually on the witness end. So let's eliminate the errors on the witness side by making sure the witness is at a place that's good, with audio that was good. And by the long story short is, by the middle of the trial, the judge was actually asking us, hey, I've got to do a CLE on remote stuff. Can you guys put together a 2-page brief on what y'all did? Because the audio's better here, the visuals are better. And at the end of the day, Tad, it came down to what we all know when we adjusted this stuff is we just made sure our witnesses were in a good, well-lit place with good audio, with good mics. Yeah. That was key. And with a plan B in place. And we learned at the other trial they did at that courthouse, that may not have been happening.
Yeah. So you ended up with a great result. So the opinion came out a couple of weeks ago, I guess, 60-40. Yes. And so my understanding is it had to be at least 50% for the government to have liability. Is that right?
In order for us to make to get the government responsible for 100% of whatever the damages will be, we had to clear the 50% 50.1 hurdle. And
is that under Texas law or federal law?
Texas.
Okay.
That's a good question. So in a federal case, FTCA case, it imports the state law, the substantive state law for wherever the act occurred. So this obviously happened in Texas. So we had to import our proportionate responsibility schemes, comparative neg, all that stuff into the federal case. And so in Texas, you have to clear that 50% hurdle for joint and several. So the court found that and found that the federal government will be jointly and severally liable for the trial that we're going to probably have this fall for the damages phase only.
Yeah. So what are the next steps?
Well, the court is going to give us in a couple of weeks a calendar to figure out how long the damages phase is going to be. So the next step is damages only trial. So it's going to be, it's going to be hard. All the families are going to have an opportunity to talk about what happened. And there's a lot of, 26 people died, but 22 people also were seriously injured. A lot of victims who suffered 7, 8, 9 gunshot wounds, children too, small children, and somehow survived. But some of them have pretty lifelong injuries. So what the challenge that we have right now, which I've been working on all week, is how do I make sure this thing is not going to be a 4-month, 3-month kind of trial and still be effective? Because as you know, it's real important to find that balance between making sure these families get a chance to tell their stories, but also making sure that it's effective and not too much, not too long, and that the horror of what happened is not sort of lost because it's just a long parade, right? And so that's kind of the challenge right now. The government's right now saying, this thing's going to take 6 months, Judge. We need 6. And I'm like, no, we need to keep this thing under a month. We need to keep this thing in a month or less. It's a damages trial. We can probably do that. But that's the challenge that I'm being asked to figure out right now, actually.
That's a tall task in a month. Wow.
It is, it sounds like a long time, but when you start breaking down the hours, and I'll say this, the thing about a bench trial is, and I don't try my cases very differently from a jury or bench trial, and people are sometimes surprised by that. But at the end of the day, it's a juror of 1 versus a juror of 12, and I don't think they get a lot of great jury trials or great trials, frankly, in the federal system all the time to see. And I think judges appreciate it. And I always tell them, my clients have a right to have a trial, and we ought to do it right. But we do modify it to make sure that, judges like efficiency, but it is hard to do that in a month when you think about the numbers and you do the hours. But we don't have jury breaks. You don't have to you don't have to do sidebars all the time. All that evidentiary stuff is handled usually. Federal judge can just move on and put more hours in the day at trial. So you can put on a ton more witnesses than you're used to than with a jury trial. You take a short morning break, short afternoon break, and a lunch break, and the rest, you have about 6 hours of 6 to 7 of real trial, which is, that is not not normal.
Right.
So that's what but even with that, you do the hours and you realize, okay, we're going to have to really be creative here to present this very unique and horrible story that deserves to be told, while also making sure it's not too long.
Does the government have appeal rights from the liability phase or at the end?
Well, they do at the end. They didn't appeal the motion to dismiss. They didn't appeal at the motion for summary judgment stage when they lost. It would have been probably a tall order, been like an interlocutory appeal that the local judge, I think they knew, was going to deny, and then to be forced to have like an extraordinary relief at the Fifth Circuit. But they haven't. And so I think they're going to, I don't know what they're going to do, but they have a right at the end of the damages trial to do that if it doesn't get resolved beforehand.
Yeah. So I guess before we hang up, give me one great fact that nobody knows, or whatever you thought was the most interesting part of the case.
Yeah, well, that's That's a great question, and I think there's probably a couple. The media wanted just to report. The media generally reports on just the sort of obvious stuff about, well, the Air Force didn't report him, and therefore, it resulted in this horrible event, and that's certainly true. But the first thing that we did at this trial was we wanted to really lay out for the judge, because we were concerned about two issues: a foreseeability issue, them arguing that it's, mass shootings aren't foreseeable. How can we be held accountable for this? And then proximate cause, the idea of, the government's defense. They hated when I said this, but they said, well, in Texas, there are no laws. Anyone can get a gun. Texas is just a gun nut state. I mean, that was their defense. And so they were saying, hey, even if we had done this, he would have found a different way. So the two things that I thought were the most striking from an evidence standpoint, and what we really built our case around at the liability phase, every day, me and my partner, Tom Jacob, who tried most of this case with me, we had made a decision strategically. We wanted every day for there to be 3 or 4 just sort of fact bombs that we wanted to drop on both the government and the defendant, the judge, new startling things that he might not have known about that related to what the Air Force knew about this guy. And the thing that was the most shocking was he had an extraordinarily disturbing mental health history at the actual Air Force base that he was in while he was there. What the judge didn't know, and what we were laying out during the trial, were a couple of just sort of surprising facts. And that was that while he was in the Air Force learned not only he had an extreme violent mental health history, but he had sexually assaulted and raped 6 different women. Oh, wow. Almost all of which were underage, and they knew about it. They had actually interviewed, and witnesses, the victims themselves, gave statements. One of which he committed while he was in the Air Force, and they learned about it and they documented it. And then the second thing was that while he was in the Air Force, we learned this through discovery, he had threatened to do a mass shooting. But he'd not only threatened it multiple times, he was actually planning one and going through the steps of planning a mass shooting and coordinating it against the Air Force while he was in the Air Force, and they knew about it.
Oh, wow.
And that was one of those, and they still got and argued, the government did, that we couldn't have foreseen this, right? And so we knew that going in. So what we tried to do was every day, and really by the 5th or 6th day of this trial, you could tell the judge was like, hold on a second, let me make sure I understand what you're trying to tell me, government. That he was planning one, he was researching one, he said he was going to do one. And then the last thing we put down was they brought in several pretty high profile experts from Stanford and Harvard to sort of talk about psychology of shootings and say it just wasn't. But as always, and I don't care where they come from, and this, they don't ever look at all the records. They just never do. And so during one of the cross examinations, I laid down we had gotten a registry from the Air Force bases across the country. They have this registry of everybody who tries to check into a base, tries to enter a base with their ID. Mm-hmm. Well, the Air Force didn't take away this guy's ID after they convicted him of 2 felonies. He still had his ID. So after he was convicted and kicked out, he was barred from the base from ever re-entering. And then they extended the bar to the entire all the Air Force bases across the country. And then after that, and our experts didn't look at this, he tried to enter the Air Force base illegally multiple times, including the base in San Antonio where we were trying the case. And it was pretty clear he was going to try to do something awful on those bases. And while I was doing that cross-examination, the judge, would interrupt me and said, "Excuse me, what date was that?" tell me the date specifically and where. And he just started writing down. I mean, it was just one of those things. And the experts had not seen that. They had not looked at that document, those documents. And that, so just putting that all together, the extraordinary extent of disturbing violence that he committed and they knew about, combined with the specific threats of mass shooting and the fact that we learned that he was planning one while he was there, really kind of put that causation foreseeability stuff to bed. But yet the government was, they went to the mattresses on that defense. And so, and I think that also played a role in the extent of the 60% finding too, because the last element of all of this, Tad, was government had known about this problem of not reporting felons to the background check system for 30 years, 30.
Wow.
And that was one of the last things I said in my closing argument. I said, Your Honor, the federal government has been avoiding responsibility for 30 years, and it's got to stop now. It was one of the last
punitive damages. Can you get punitives in this case?
No, but that's one thing the FTCA doesn't allow. But boy, if there ever was one, I mean, this is one of those, there ever was one. And so we tried to really align that sensibility with the finding of responsibility, because of course they're saying, how can you make us more responsible than the shooter of this horrible event? And that has I can understand that position, but what we were trying to establish was this, as with any one of these cases like this, is that it wasn't just preventable, it's predictable. And when you have this kind of history, you are just begging for this to happen if you don't fix it. And I think that combined with the fact that we introduced evidence that not one high level official in the government was ever punished for this. They issued not one, and they issued these little silly letters of reprimand that would go into someone's file and have no effect onto the guys at the bottom and girls at the bottom of the totem pole. Never anybody, because we had generals, with stars on their shoulders who were responsible here, and all the way up, and they did not get. There was no accountability there, and I think that bothered, as it should, the court.
As it should. Well, Jamal, thanks for being on. Congratulations, tremendous result, and what the damages phase. Good luck on that. What an uphill battle, just getting it done, like you said, without it being redundant, and getting the judge to understand what these families went through, each and every one. But great job. You must have worked the heck out of the case. So,
thank you. Yes, it has been. It's been the biggest sort of workload and commitment that I've had in a long time, but it's been very much worth it. And it's interesting going into a damages trial after a mass casualty event, knowing that, that's all we're going to be talking about. So it's an interesting new challenge to just form and shape a trial just around that. So I can't wait to tell you about it, and I certainly hope it goes well.
We'll have you back on when it's done.
All right. I can't wait.
Thanks. Wasn't that interesting?
Yeah, fascinating stuff. Learned a ton from it.
It's such a massive case logistically. And, how do I think it's great that so many lawyers deferred to him and his firm to kind of take the lead, because on a case like that, you just can't have too many cooks in the kitchen. It's just impossible to do. It's hard enough when we have cases with 3 or 4 or 5 plaintiffs, but to have, was 26, 27 killed and, plus wounded, just massive logistically.
Yeah. And how he thought, you know what, I'm going to do this strategy that it's pretty risky. It's a pretty risky strategy, but it had worked out obviously on that part of it. I actually want to now fly down to watch him do the damages portion of it, but it's going to take a while. We'll have to have him come back on after that happens and give us a breakdown.
Well, and I'd love to see the news cover this again, because there were so many facts about what the Air Force's knowledge was that I don't remember hearing, and maybe I didn't pay enough attention. I don't remember hearing that in the news coverage, but that's something that people need to know, that, hey, you had people with stars, on their shoulders that knew how bad this was, this conduct that the Air Force was engaged in, and did nothing over years.
Right. And a trial attorney brought to light. Well, a tragedy brought it to light, but not the way that the obviously media covered it. And it's incredible. And one of the things I took away from it was those facts you're talking about, how he employed them throughout, or deployed them, I guess, throughout the trial, which was one fact bomb a day. Mm-hmm. And then the judge arrives at this point to where he's stopping people and saying, wait, did I hear that right?
That's right. Yeah. Yeah. And I like doing it witness to witness too. That's my whole theory on cross is I need one good fact for every one of their witnesses that they call. I don't need to cover, if it's 5 witnesses, I don't need to cover all 5 facts with all 5 witnesses. One good fact per witness. And, it just takes away everything that each one of those witnesses testified to that might have helped the defense when you have, some obvious bad fact for the defense that you can hit them with. And, hopefully the jury just tunes out to whatever they're saying.
Don't overtry the case.
Yeah.
Just just get in, get out.
Well, hopefully my theory works. I'm getting ready to go into 3 back-to-back trials over 6 weeks. So we may not be recording one of these for a while.
We've been, it's been slim pickings. I mean, you and I both, we haven't been on a podcast together for a minute. And then we've got a case autopsy through Lawyer Minds that hasn't done one in a while. And that's because Chris and I have been trying cases. And so, I'm delighted. I'm happy. I'm sorry for everybody who listens to these and enjoys them. Besides maybe my family and my friends,
our parents,
our parents.
Yep.
That is our primary responsibility. So, best of luck to you in those trials, man.
Well, thanks. Hopefully I win at least one of them. So
yeah. You'll be batting. Hey, you know what? They say if you bat 300 when you're trying cases on the plaintiff side and you're writing books. So,
well, that's what I'm going for. If I win 2 out of 3, I'm Hall of Fame, right? So
there you go, buddy.
All right, Mike. Good seeing you again.
You too, man.
That wraps another episode of the official Lawyer Minds podcast. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content Lawyer Minds has to offer and engage with us on social media. Your feedback on the show and ideas for future shows is always welcomed. See you next time.